Next item. How do you write a motion? All right? When you go to write a motion, it's simply a letter. So let's pick a motion out here. Let's take one, and I want every one of you to get your yellow pages or yellow pads out. And I'm just going to take a simple, easy motion and see if I can find one here. Okay, let's take why don't we take a motion for a subpoena ducis tecum, which is number 5. Turn over here to number 5, and let's see if we can write a motion for a subpoena ducis tecum. That's just one page. I'm sure that we can all follow through and just do one page. All right? So I'm going to pause right now at the end of this tape, and here's what I want you to do before you turn it over. I want you to, before you go on, I want you to take this page, which is number 5, and I want you to put your name, address, and your phone number up in the upper left-hand corner, just exactly the way you see this. I want you to write this out in longhand. Yeah, I know that's a wicked homework assignment. You haven't done that for 20 years. But if you're going to do this in the courtroom, you're going to learn how to do this, because not every motion is going to come out of that computer. And this motion for subpoena ducis tecum is one that you've got to motion up yourself. And I want you to write that out in longhand just exactly the way you see it right here. And then when we get through with that, we'll come back and we'll take a look at it and we'll analyze it, and I'll show you what you've done. All right, now you've got the motion for subpoena ducis tecum completed. You should have it sitting right in front of you in longhand. You should have in the District Court of the 4th Judicial District of the State of Idaho, in for the County of Ada, case number 25C1166. You should have your little box in there and all of the right numbers, and there's 2 paragraphs. If you'll read along with me here, we'll go through it and then we'll explain what this is for, what it is that you're after. One thing you want to always keep in mind, that a motion has to be specific and you have to want something. If you want an ice cream cone, you go to your daddy and you say, "Dad, I need a dime for an ice cream cone." That's what I used to say. And he'd say, "Why?" "Well, because I haven't had an ice cream cone for a whole week and it's Sunday and all the rest of the kids have got ice cream cones, and I don't think it's unreasonable for you to give me a dime for an ice cream cone this Sunday." Well, okay. Then he'd give me a dime and I'd go down and buy an ice cream cone. All right? And you're not doing anything differently here with this motion for subpoena ducis tecum. Now, this subpoena ducis tecum is a demand for the government to bring forth evidence. The government normally serves subpoena ducis tecum on citizens to bring their records and books in for an examination at the suit of the state. Okay, well, in this case, you're going to pull a renvoy. You want the evidence brought into court so that during this preliminary hearing, you'll have an opportunity for examination and cross-examination of the officers who have this physical evidence or seize this physical evidence to talk to them. And this is what this was about. There was a preliminary hearing, and I motioned up the court to order the prosecutor to see to it that they brought this in so that we'd have it right there in the courtroom. All right. Comes now the defendant in the instant case, claiming all of his rights under the common law and waiving none of them at any time. Now, notice, your opening statement. Always make a demand for rights, and if not every time, at least every 3 or 4 motions. Always make sure that the record is clear, because if you don't, at some point in time they'll say, "Oh, well, he waived those rights." Yeah, yeah, he waived those. When I walk in the courtroom, about the first thing I say on the record is, "Let the record show I'm appearing here against my will and over my objection, challenging the jurisdiction of the court. I'm here because if I don't appear, you'll put me in jail, not because you have proper jurisdiction." Oh, in this case here, I'm demanding all of my rights at all times, and I waive none of my rights at any time. I'm appearing by motion, not granting jurisdiction to this court as the issue of jurisdiction is in question. All right? Here's what I want. To order the government to bring forward at the probable cause hearing any and all rags alleged in the complaint to have been destroyed by this defendant on or about April 9, 1982. These rags are necessary and imperative to the defense in the instant case. As it turned out, they didn't bring the rags. When they didn't bring the rags, I got on the record and I said, now, Your Honor, we don't have the physical evidence. Why are you denying me an opportunity to face my accusers with the physical evidence so that they'll look at it and we can ask questions about the stitching and how the stitching was removed and about the tears and what tears and where it came from and if they'd ever seen them before? I'm being denied a meaningful hearing. I'm being denied an opportunity to defend myself with the physical evidence, and it's necessary and imperative that I have it. And I move that this hearing be postponed until that can be brought forward. They didn't do that. They just said, we'll just go forward without it. You don't need it. Okay, but you've made your objection on the record. And when you've finished this particular motion, you've now written a motion. What's the big deal? Probably for the first time, some of you have actually written a letter. This is a letter to a court. Nothing more, nothing less. Now, at this point, it's necessary to make a comment about what a motion is. When you look up in Bouvier's Law Dictionary the subject matter of motion, you read the argument in there, and under jurisdiction. When you motion the court and ask them for something, you're granting jurisdiction to the court. All right, so you have to be aware of that going in. If you ask the court to give you something, it must have the capacity to grant it, or if it grants it, it must have had the jurisdiction or the capacity to grant whatever it is you wanted. That being the case, then you've waived jurisdiction and you're granting jurisdiction to the court. That's the problem you have when you have a lawyer come into the case, because the moment he enters the case, it's obvious that the court has jurisdiction because he's a competent and paid professional licensed by the state, and if the court wasn't of competent jurisdiction, he wouldn't appear there, would he? He would order the court or motion the court to transfer the case to the court of original jurisdiction. And since the lawyers all belong to the union and so do the judges and the prosecutors, it's just one big happy family. You won't find very many lawyers who are going to go in there and argue rights for some indigent citizen who's arguing some off-the-wall tax issue about labor not being taxable. If you'll notice here, I was charged with destroying a jail suit. These guys wanted to put me in prison for 14 years for that. You can read through this entire case. This is called a sample criminal case. You got this in lesson 9. I'd recommend I know it's a lot of reading, but I would recommend that you read all these motions in here, not because these motions are only applicable to me or because the motions or the briefs are only applicable to this case. You see, many of these motions in here are the same kinds of motions that you're going to use in every case that you prepare. When you're looking in here and you've got a rights jurisdiction brief or you've got a motion for dismissal for failure of the jurisdiction, you're going to use the same thing, or you certainly can. And I would encourage you to do that. By reading these, what you're going to see, and then your gray matter is going to take into itself, your brain, that is your mind, is going to begin to think and to store this material, and you may not be able to regurgitate it. I absolutely loathe this baloney of trying to memorize things. I hear people all the time, talking about memorization. You have to memorize this and memorize that. I think you need to learn it, not memorize it. I talk to people all the time in judicial circles, and they can sit there and they can spout off about 10 or 15 statements, and those 10 or 15 statements are something that they memorized in law school. And here's what they are. These arguments, Your Honor, are specious, they're frivolous, and without foundation and merit. Your Honor, Mr. Gordon's arguments are totally frivolous and specious and without foundation and merit. This court shouldn't take any cognizance of Mr. Gordon's arguments because they're specious and frivolous and without foundation and merit. And yet that record just drones on and on and on and on. And it just doesn't seem to me that these people are able to go into the courtroom and think for a moment. Because, if I went into the courtroom and I see an argument somewhere, some judge gives me a court case, the first thing I want to do, well, gosh, maybe I learned something here. Let me go read this. And I'll go read it and apply it to the circumstances, and I'll say to myself, wait a minute. This doesn't fit this circumstance. So this is off point. When you read Almeida Sanchez, here's the government lawyers. Remember this lesson from Almeida Sanchez, somewhere down around lesson 4 or 5 or 6. If you can't remember it, then go back and review Almeida Sanchez and the 2 key cases that the government brought up. They claimed in the Sanchez case that this Mexican hauling marijuana was breaking the law and that they had every right in the world to stop him out there on the highway and to search that vehicle and find that marijuana. All right? That's their position. And they said, Colonnade and Biswell. And the Supreme Court looked at it and said, listen, you government lawyers are out to lunch and off the wall. Colonnade and Biswell were two regulated enterprises that had licenses. One of them was in the liquor business and the other one was in the arms business. And whenever you're dealing in trafficking in guns and ammunition or liquor, there is no expectation to privacy. And there isn't any question as to whether or not you're going to be effectively regulated. So here's your government lawyers coming in with these two regulation-type search warrants. When you go in to Colonnade or Biswell, and I guess what happened there is that these two corporations, these regulated enterprises, complained about being investigated without search warrants. And the court ruled in those cases they don't need warrants, dummy. You're licensed. And they pointed out that Mr. Sanchez wasn't licensed and he had an expectation to privacy. That's the lesson in how to stay on point. And I think they need to teach that in law school. Now, one of two things. Either these lawyers that we're running up against in the courts are extremely ignorant, or they're not ignorant. What they are is willing hypocrites who come into the court and declare that the citizen is arguing frivolously when they know better. Either they know the truth and they are willingly rejecting the truth, or they're stupid, one or the other. All right? I don't know which it is. I would rather think that they're just stupid, because I don't like to impute evil motives, because if they know the truth, and they do read the words and the sentences and the paragraphs, which I don't think that anybody who's been in the 6th grade couldn't read a Supreme Court case and just see the plain, easy-to-understand language. If you think that's difficult, review Marbury versus Madison, wherein they said the plain language of the Constitution can't be interpreted. It just has to be applied the way it just plainly tells you to apply it. That's the message of, or one of the messages of the Marbury case. That, you know, when you're putting a construction on a particular sentence or something, you don't need 15 law professors to sit there and argue and harangue for 4 hours as to what it means. When Christ told those apostles or his disciples at that time, he just said, I'm speaking in parables so these guys can't understand what I'm saying. Can it be any plainer? Now, I don't know. Maybe that is offensive to some people. I think it got offensive to this Mrs. Ray because, boy, you should have seen me come back to Sunday school the next week. I couldn't wait to get back. Now we had controversy. And I went in there and I showed her that, and she just couldn't grasp that. And she sent me to the preacher. And I said, we've got an error here between the Sunday school lessons that are coming out of Missouri and Scripture here. And I can see right now that this isn't right. And this has got to be corrected. And I don't know. He sat there and preached me a sermon for about 20 minutes and totally scrambled my brain and showed me how I was wrong. And I walked out of there and I'm going, I couldn't grasp that. I don't think I ever went to church again for 15 years. I have a problem with preachers. They don't seem to be able to stay on point, and I have a problem with lawyers and judges who can't stay on point. Now, that isn't true of all lawyers. There are some good fellows out there, and there are some good judges out there. But occasionally you'll run across these judges, and when I'm talking to people in Illinois, I mean, you got some real corkscrews out there in Illinois. I can't believe some of the stories that I hear from some of these other states. And that state of Washington up there is a real police state. That's something to just blow your mind. Okay, let's go on to the next issue. Now, you've written one of these. Let me just finish this subject of writing, or how to write one of these motions or briefs. When you're writing these, you want to make sure that you're specific, that you don't wander around asking 14 questions. A motion should be a motion that is specific, that it asks for a specific item. Don't sit there and talk about your great-aunt regret and, gosh, the weather's been so bad and terrible here. The weather has nothing to do with that motion for subpoena ducis tecum. There's just one item that we want. We want those jail clothes. We want them in that jail. I mean, in that courtroom. We want them in there on that day, and that's all. Stay on point. Talk about one subject at a time. When you get off point, that judge will sit up there and say, oh, you're off point. When he gets off point and tries to change the subject on you, be sure you call him on it. Judge, let's stay on point here. Let's get a judicial determination as to what the subject matter is. And this subject matter is a subpoena ducis tecum for those rags, and I want those rags. Are we going to get them or not? No! All right. Let the record show I object and I can't move forward without them. And then you'll say, well, we're going to move forward anyway. Well, let the record show then that I'm being fettered in my defense. And I believe that word fettered counsel comes from a case called Ferretta versus California. It seems to ring a bell. Okay, now the next thing is how to argue these motions. Now I've been going through and I've been arguing some of these up to this point in time. And arguing motions, you know, is what really is the fun of going into the courtroom. Now, one of the things you're going to notice, and this is especially true in Idaho, is that the prosecutor sits over here like a dunce on a log. He doesn't say anything. He just sits there and says yes, sir, and no, sir. And it's absolutely amazing. There isn't any procedure here. We have an empty form without any substance. The way it's supposed to work when you're talking about an adversary proceeding is you'd come in and present your motion and your arguments, and you'd rant and rave and jump up and down, paw the ground, bite the bushes. And then, are you finished, Mr. Gordon? Yes, sir, Your Honor. Thank you, Mr. Gordon. That was a wonderful presentation, and I appreciated that very much. Mr. Prosecutor, do you have any rebuttal? Yes, sir, Your Honor. And he'd stand up and he'd rant and rave and jump up and down, paw the ground, bite the bushes. And he'll sit there and act. Gordon is bringing frivolous, specious arguments without foundation and merit. Yeah, that's the way those prosecutors are. But at least make him say it. What's happening here is that the judge conducts the entire inquisition. You go into a motion hearing, are you ready to move forward, Mr. Gordon? Yes, I am. You make your arguments, and then the judge sits there and refutes your arguments. Instead of being the neutral referee, he's intercepting passes and running into the end zone for your opponent. What you need to do is say, excuse me, Your Honor, maybe I don't understand what's happening here. Are you the prosecutor or the judge in this case? It was my understanding, sir, that the prosecutor would rebut my arguments, and then you would make the decision as to whether to dismiss or to overrule. I've been into courtrooms where they'll actually take the defendant and put him on the witness stand and ask him questions in these motion hearings. Some of the craziest, dumbest, upside-down, warped procedures you can imagine. Of course, when you're in the captain's mast in an admiralty circumstance, you know you're on the good ship Idaho, and they just run this good ship Idaho like they were running it out there on the high seas. There's no common law or due process, but that's 90% the fault of the defendant sitting out there. You know, failure to assert your rights timely waives them, and failure to object timely is fatal. So said our old friend Hugo Black. So, you know, when you get into that courtroom, as soon as you see the procedure beginning to stray and deviate from the rules, what you've got to do is say, excuse me, Judge, I think I misunderstood something here. I'm going to have to ask the court a question. And of course, when you walk in there, you know that that prosecutor is a judicial officer under the 5th article, and you know that judge is a judicial officer, and of course that's an objection that you need to be making under the there's a motion in here pursuant to this prosecutor and public prosecutor, as prosecuting attorneys and public prosecutors. And that's just one of the issues that you're going to bring up, and of course you need to bring that up when you walk into the courtroom and you're witnessing this. That isn't always true. Sometimes you'll find a judge that'll sit there with his neutral hat on and he'll make that prosecutor over there go to work. I was in court the other day and we did a civil case. And the judge sat right there and he told that other lawyer over there, he says, you write your briefs and motions and I'm going to order you to make a response here to Mr. Gordon's constitutional questions. I think the reason for that is that some of these judges around here are getting tired of having to go do the legal research for these lawyers. The lawyers tend to be fairly incompetent. When they get into the courtroom, they're relying on the judge to make the decisions, and they just kind of yes, sir, and no, sir. And take a look in the courtroom and see if that isn't what you see. You know, a lawyer's got a lot of work ahead of him. If a lawyer gets into the courtroom and was really working for a client on the scale of William Jennings Bryan and and the Scopes Monkey trial with Clarence Darrow, you know, that was a toe-to-toe, head-to-head combat. I mean, they were in there arguing points and facts and witnesses, and we don't have trials like that anymore. Go into the courtroom and observe that and see the difference between some of those old-timey, I saw the movie or some old shots of that Scopes Monkey trial, and I mean, those guys worked hard at that. They don't do that anymore. There are some cases that come down where there's a lot of lawyers work, and I'm not saying they're all like that, but boy, down here at the lower levels, you're not going to find lawyers. You show me a public defender that'll write that much paper and do that much research for a client, an indigent client. Why, it's unheard of, absolutely ridiculous. And then when I do it for somebody, and when I help somebody, and then they sit there and say, well, this is all frivolous and specious and without foundation and merit, and these motions have already been tried in the traffic court, and they're all overruled, and they're all a bunch of phony baloney, and you better go get a licensed lawyer. You know, all I can do is sit there and say, why don't you get a couple of good lines in there? Judge, which one of these motions is frivolous? Well, they're all frivolous. Well, let's take a look at one of them then. Show me how this is frivolous. Let's get back over here now, Judge, to... Well, let's just take one as an example here. I probably am frivolous and specious, and I want you to show me how this is frivolous. Let's take a look at number 28, Your Honor. This is jurisdictional brief, rights in support of demand for dismissal. What is it about that? Make him specifically and absolutely point out the third paragraph on page 1 is absolutely unconstitutional, it's unlawful, it violates the rules of procedure, it does this, it does that. And then you better be able to overcome his argument. And besides that, who in the hell is the judge to be making an argument like this? Why don't you tell him, Judge, why don't you make that prosecutor over there go to work? He's sitting over there like a bump on a log. It's about time he rebutted my arguments over here. I'm demanding rights, and where rights are involved, there can be no rulemaking or legislation that would abrogate my rights. So says the Supreme Court in Miranda, page 491. Now, I'm demanding my rights. Now, what is it about my demand for these rights that's improper, that's illegal or unlawful? Now, do you see the way you get in there? You've got to be that belligerent claimant in person. You go into a courtroom and you're kind of a timid Tilly. Your Honor, I filed this motion on rights. Does it meet with your approval, sir? Is it okay with you? No. It's specious and frivolous and without foundation, without merit. Oh, I'm awfully sorry. Excuse me, sir. Now I have another motion on merchant at law, sir, in support of demand for dismissal. Would you dismiss this case because of this? No! And that's specious and frivolous and without foundation and merit. It has no place in this courtroom, Mr. Gordon. Oh, I'm terribly sorry, sir. Excuse me. Let me see. So what's that going to get you? You know, if a man's going to be a free man, he's going to have to be the belligerent claimant in person. Let me read this into the record now for some of you that are new. Some of you people take up at lesson 8 or 9, and maybe you've missed some of the earlier lines. Where is that? That's number 32, isn't it? Here it is. The privilege against self-incrimination is neither accorded to the passive resistant nor to the person who is ignorant of his rights, not to the one who's indifferent thereto. It is a fighting clause. Your rights, whether it's the Fifth Amendment or the Sixth or the First or the Second, those are fighting clauses. I didn't write that now. Don't get mad at me. That comes from a case called United States versus Johnson from 76 Federal Supplement 538. That isn't my lines. I wish it were. Gosh, I wish I was smart enough to come up with some of these nifty lines that the Supreme Court of numerous states and the Supreme Court of the United States comes up with. You know, I read lines like these to these district court judges and magistrates, and you might as well try to drown a duck. I mean, they just sit there and look at you like, your motion's overruled, Mr. Gordon. Your motion's overruled, Mr. Gordon. I'm going to overrule all of your motions, Mr. Gordon. I'm not going to listen to all you. I'm just telling you, you're casting your pearls before swine. But you do this because it's an absolute necessary prerequisite to getting this case appealed to the Supreme Court of the United States. Because if you don't make these arguments and these motions prior to going forward in that trial, then you haven't established your theory of the case, and you haven't objected timely, and failure to object timely is fatal. Don't think that you're going to raise these issues of jurisdiction after the trial and then take them to Washington and say, well, they didn't have jurisdiction when I went in there. I argued the merits of the case, but, and I paid bail and I granted jurisdiction and I made motions and I granted jurisdiction through the motions, etc. I mean, just forget about that. Its benefits going on here, your rights or the benefits of your rights can be retained only by sustained combat. It cannot be claimed by an attorney or solicitor. You see how? What do you want to go to a lawyer for? Lawyers don't claim rights. And you know what a solicitor is, don't you? Why don't you go over to New York? They've got some out there in what they call Times Square. They call those solicitors, those ladies of the evening. And don't get mad at me now. If you're a lawyer out there, that's your Supreme Court calling you lawyers solicitors. So you cannot be claimed by an attorney or solicitor. It's valid only when insisted upon by a belligerent claimant in person. And when I say belligerent claimant, I'm not sitting here telling you to commit contempt of court when you get in there by saying, Judge, you're nothing but a fairy and a panty waist, and start cussing one thing and another in the courtroom, because if you do that, you're going to end up in jail for 5 or 10 days. Being the belligerent claimant in person sometimes is just using a little reason, logic, and common sense. Let me see if I understand your position here, Judge. Are you telling me that I don't have any rights? I've asked judges, have you read this brief, sir, and are you thoroughly familiar with it? Oh, yes, I've read all these motions, Mr. Gordon, and I'm going to deny them all. Oh, well, excuse me, sir, but this is a motion hearing, and I've demanded oral argument, and I'd like to proceed now with the oral argument. Well, that really isn't necessary. It isn't going to change my mind. I've had judges tell me that. Oh, I see. You've already made up your mind. Well, I guess you've already made up your mind that I'm guilty, and therefore you're not neutral any longer. And I'd like to move at this time, sir, that you disqualify yourself from this case for extreme prejudice. Oh, I'm not prejudiced against you, Mr. Gordon. I'm going to make sure you get all your rights and blah, blah, blah. Wait a minute, Judge. You just made the admission yourself. You just told me that you've already made up your mind. I haven't even given you my cause of action. I haven't even expressed or expounded on a single motion, and already you've told me you're going to deny all of them. You've made up your mind. Those were your words, sir, not mine. Now, I demand that you disqualify yourself for extreme prejudice as a matter of ethics, as a matter of judicial canon. I've done that a few times, too. You do that to him once, and he'll never make that mistake again. All right, when you're arguing a motion, remember, now we went through a motion hearing at Lesson 7, and you got to see, and you know, when you get into court, what you're going to do to argue a motion. So it isn't necessary in this lesson to sit here and run over Lesson 7 with you again. What I want to point out now is, remember, this isn't a reading lesson. And I don't know how many people I've told this. I've done it myself, so I'm going to repeat it to you again. And then after I've warned you and told you don't do it, you will go right out and do it anyway. I know that. But at least when you go out and make the mistake, you won't be able to say, I didn't tell you. So let me tell you, I told you so, before you do it. What you're going to do is you're going to order the motions, you see, because you're busy and you don't want to write them yourself because you're lazy. Then you're going to take them, and because you're in a big hurry, you're going to file all of them and you're not going to read them. Then you're going to go into court to argue these, and you're going to expect the judge to sit back and say, oh, Mr. Gordon, I've read all your motions and I just agree with you wholeheartedly. You're 100% right. Case dismissed. See, that's what you want. That isn't going to happen. I've been doing this for 5 years, never had that happen yet. If I do it for another 50 years, I don't ever expect that to happen. I don't believe it for a minute. You're not going to read the motion. And one of the more classic cases just came up the other day. There's a nifty thing in here called a demurrer. And it's pursuant to traffic cases. And it's got about 4 or 5 citations of Idaho Code Chapter 49 in it. And this young fella, he took all of his briefs and motions. He's green as a gourd, and he just filed them. And this judge read it. He's charged with drug violations, and he's got a motion or a demurrer in here pursuant to a traffic case and driver's license. And he goes on to say, and I don't have a driver's license, and therefore blah, blah, blah. And Idaho Code 49-317 says. You see, if he had read that motion, or the brief, or the demurrer, and it had gone through, he would have seen driver's licenses, Title 49, traffic code doesn't have anything to do with my case and my facts. I'm charged with a drug violation, and this is a traffic case. Now, the principles of this thing called the corpus delicti are the same. You know, if you're dealing over here in contraband, that is, you know, during the Volstead years, people were dealing in booze. Now that was illegal and unlawful because it was a constitutional amendment. What we're dealing with here with marijuana and these various drug laws is contraband, which is nothing more than commercial code. Government doesn't want you to deal in marijuana because it's not licensed and taxed. If it were licensed and taxed like tobacco and alcohol, you know, they'd just be out here. You know, you'd have brands of marijuana. This is a super brand, you know, Lucky Strike marijuana, you know, or Camel marijuana, you know, that's all you'd have. And so anyway, if you're caught trafficking in this thing here, you know, it still requires at the common law that there be a victim. What loss has been suffered by who, and who inflicted the loss? How did it occur? What's your cause of action? What damages are you seeking, etc.? There would be the common law. And you'd take this case to a grand jury, and the prosecutor would say, well, this guy sold marijuana over here to my 10-year-old girl. Oh, I see. Mm-hmm. Well, that's like a guy selling cigarettes to your 10-year-old girl. They're poison. Or selling whiskey to your 10-year-old girl. You see, I think that a grand jury, I think that the citizens out there would say, yeah, I think we've got a damage. I think we've got a trespass. I think we've got a crime here. Well, what if the guy's 25 years old and you sell this guy whiskey and then you charge him with a crime? You sell him cigarettes, you charge him with a crime. You sell him marijuana, you charge him with a crime. You see where your problem is? The reason that selling marijuana is a crime is because it's a statutory uniform code or uniform commercial code crime. It's a violation of business practice. It's like selling alcohol to an 18-year-old. That's a violation of business practice. It's like selling alcohol at 2 o'clock in the morning instead of 1 o'clock in the morning. It's a violation of business practice that has to be done under contract. That's civil law. All right? So if you're talking about civil law versus common law, there can be no crime at common law for selling marijuana to a guy that's 25 years old. This can't be. It's a crime because it violates the civil law. It violates what the people have decided through their legislature will be the new morals of the community. We don't have morals based upon Scripture. We have morals based upon the legislature. The legislature will tell us what's good and bad. So, you go into the courtroom to argue a position, and here's this guy filing motions that he hasn't even read. Look at the foolishness of it all. The judge looks at it, and he says, this comes out of a computer. This is a bunch of tripe. And the judge is exactly correct. And that's exactly what you're going to do. I don't care whether you file one motion or 30. If you're going to file one, and you read it, and you study it, and you know it, and you understand it, and it's counsel, and there's a brief in support of it, and you go in and argue that correctly, you're better off than filing 30 motions that are off point, and out to lunch, and off the wall, and then are really frivolous and without foundation or merit. And I know I've done it in the early days. I filed motions. I even had the captions on some of my motions in the district court of the state of Colorado, filed them right here in Idaho. And the judge said, where are we, Mr. Gordon? Where are we? Yeah, do you know what state and county we're in? Yeah, this is Gooding County, Idaho. Oh, I was reading the captions on your motions, Mr. Gordon, and I wanted to make sure that you knew where you were. That's right. Made a total ass out of me. Once. Can't do that to me again. You know, fool me once, shame on me. No, fool me once, shame on you. Fool me twice, shame on me. So whenever you get briefs and motions out of the computer, whether you write them, well, I guess if you're writing them yourself, you'd know what you've written. But I've written motions in longhand and given them to my secretary and said, put this on paper, and then you go file them, and you find out that your secretary has inverted whole paragraphs, and when you get this thing written that came out of my secretary's office, it's something not totally different, but something different than what I wrote or what I had intended to say. I've had that happen many a time. Before you walk into that courtroom, you read it, and you know what's in there. Otherwise, don't file it. That's the biggest problem that we face, is having cases where a guy starts to school here, and he's got 4 or 5 lessons under his belt. He's seen 4 or 5 videotapes, and now he gets charged with a crime. And now he's out here calling up saying, well, now how do you file motions? What are they? And I've had guys, say, well, why? Why do you want to file motions? And I don't want to sit here over the telephone, and talk to you for 2 hours, while you're out here on the other side of the country trying to get information one at a time. That's why I've always recommended you need to learn first at the 3-foot end. Then when you jump in the 30-foot end, you're ready to handle it, and you can talk about technical matters, not just the routine, mundane things, well, what is a motion and how do you use it? Okay? I guess enough said on that subject. That's the way you argue motions. Reason, logic, and common sense. Just sit there and listen to what that fool says. Whatever that fool puts forth from his mouth is what you want to rebut or refute. And that's where you need a couple of nifty and keen lines. Let me put that down for a moment. Now let's bring up the subject of constitutional issues. The constitutional issues are going to be heard by the Supreme Court of the United States. The other day in the paper, you've probably seen this, it's been on television and radio and talk shows. I first saw it on Good Morning America. There's a black man down in Los Angeles, California. And I mean to tell you, that guy is a mean-looking dude. I mean, you can just look at the picture now, and if you're black, now I'm not down on blacks, but this guy, he's got funny-looking hair, and I mean, this guy would scare you at high noon in a park with 3,000 people around. I mean, this guy he just kind of looks like I don't really want to get too close to him because I don't know what he's going to do. And he likes to walk around at 2 o'clock in the morning on Wilshire Boulevard with a television set in his arms. And, just picture this, here's this black dude in a white neighborhood at 2 o'clock in the morning carrying a television set down the sidewalk. If you were a policeman, do you think you'd stop and ask him who he was and what he was doing and why he was in that neighborhood? I mean, he looks dumb as a post. I mean, you look at this guy, and he looks like he belongs down here in some penitentiary or something. He doesn't dress in a suit and tie and one thing and another. He was on Good Morning America, and I was looking at this, and I think it was David Hartman said, well, you're arguing this case to the Supreme Court, and well, what is it that you're doing? And I mean, the words flowed out of this guy's mouth as if he was a justice on the Supreme Court himself. He just sat there and quoted Brown versus Texas in this case, and Marbury versus Madison, and here's the way the law is, and here's Miranda, and I've got rights, and here's what my rights are, and here's what the issues are. Well, what he'd done, he snookered the police. You see, he was trying to test a law down in California that says that you have to identify yourself when a policeman comes up to you. And this case has already been decided in a case called Brown versus Texas, and we looked at that one a little earlier. Well, if you'll notice, California put in an amicus curiae, and they went in on the case with Texas. And down in that California police state, they decided that when a policeman comes up to you and demands to know who you are and give him your social security number and driver's license and one thing and another, that you have to do it. And this fella, he's decided that he's a citizen. More power to him. He decided he was a free man. Now, I didn't know there was too many of these free men around, but there's one down there in California. You got him. He's down there in Los Angeles. He's in the paper the other day. He won.